what I propose to do, if I may, is to deal with copyright first, then to go on to deal with justiciability, and then to deal with a WUSU. But just to lay down a marker about a WUSU, it's not really a separate point from justiciability, because it contaminates quite a lot of the arguments available on justiciability, insofar as it might be said that justiciability is a good thing to have, because the difficulties of it can be mitigated by a doctrine of forum non-conveniens. If there's one thing WUSU makes clear, is that the doctrine of forum conveniens is no longer available. But I'll come to all that in due course. Can I start then with copyright? And before coming on to the main question, which is that of sculpture, deal with sections 51 and 52 to see why they're there and why we rely on both of them. You'll find them in the bundle 1, tab 8. Section 51 first. Under the law as it stood before the 1988 Act, there was a mischief, or at all events, a consequence of the statutory regime, that copyright in drawings was being used to protect things which were not copyright works at all. And this wasn't just silencer systems for British Leyland motor cars. It was boats, it was dresses, which might sometimes be works of artistic craftsmanship, but frequently aren't. It was toys. It was all sorts of objects, none of which were themselves works of copyright. The 1988 Act made provision for these things to be protected in a different way. Section 213 of the Act introduced for the first time a right of unregistered design. We see it's a section starting at section 213. It's over the page from section 51 in the bundle you've got. And it describes the so-called unregistered design right. This was a new kind of protection. In a sense, it perhaps dealt with the point Mr. Justice Whitford had made in the J. Davis case, which your Lordships looked at yesterday, in bundle 2 at tab 22, when he observed that in the absence of an unfair competition law, copyright works have been stretched, so to speak, to create protection which perhaps they were never intended to achieve. I'm paraphrasing what he said. And what this new statutory provision set out to do was to provide an unregistered right which was independent of copyright and which arose from the mere fact of from the facts which were necessarily established in order to get the right. But what they didn't require was an original copyright drawing to base your case on. And as that right was given, so Section 51 took away the ability to rely on the copyright in one kind of work to get protection for something which was not a copyright work at all. And that's why it's drafted in the way it is. If what we were making was in fact a copyright work, then Section 51 does not help us. The claimants are entitled to rely on their copyright in Mr. Macquarie's drawings to contend that something we made which was a copyright work was infringed. If, on the other hand, what we made is not a copyright work, then what we did does not infringe the copyright. They would have had rights under the unregistered designs provisions, but those don't last very long. 10 years at that particular time. So, if I'm right that this is not a sculpture, then Section 51 provides me with a defence. And if I'm right about that, I don't need to go on to Section 52. And your Lordships may be wondering why Section 52 is in the case at all. It's actually there for two reasons, one of which is no longer relevant. The claimants contended before Mr. Justice Mann that the object we were making was either a sculpture or a work of artistic craftsmanship, or perhaps both. As a work of artistic craftsmanship, it would have been entitled to copyright. Section 51 would not apply. Section 52, on the other hand, we say would still apply. And I must now go through and explain why. It stems from the fact that the claimants made toys which used all the features of the copyright works. In fact, if your Lordships would care to see the toys, they're now in bundle 6. There's some illustrations of them just to show what the point is. In bundle 6, at, I hope, tab 19, there are some examples, and these are only examples, there were many thousands more of all sorts, but these are the ones that were around at the time of the trial. I don't think we had the actual products, we only had pictures of them. And what we see under tab 19 are the sort of fairly familiar toys which merchandisers put out as a result of the success of a film. And it was conceded at the trial that these toys did have the necessary effect of bringing Section 52 into effect, unless they were to be regarded as sculptures too. Because if they were sculptures, then they did not. So turning now to Section 52, your Lordships will see that Section 52, subsection 1, says this section applies where an artistic work has been exploited by or with the licence of the copyright owner. It doesn't say where artistic work is intended to be exploited at some future time. It's not in the same form as Section 22 of the 1911 Act. If your Lordships would turn back to that at page, at tab 4, the two are worth comparing on this point. Section 22(1) says, this Act will not apply to designs capable of being registered under the Patents and Designs Act, except designs which, though capable of being registered, are not used or intended to be used as models or patents to be multiplied by an industrial process. Now, the House of Lords in the Popeye case construed those words as saying, as meaning, that one has to judge the question of whether they were used or intended to be used as models or patents at the time the designs were made. So that if there was a subsequent intention to use them, Section 22 did not bite, which is why the claimant won, or plaintiff won, in the Popeye case. What had happened was that the cartoons of the Popeye character had been around for some years, and it was only later that their popularity inspired the making of merchandise products, dolls and so on, badges. And because at the time the cartoons had originally been made, there was no intention to use them as models or patents, Section 22 didn't bite. That's the 1911 Act. But when we turn to the Section 52 of the 1988 Act, there's no reference to not used or intended to be used as a characteristic of the drawing at the time it is made. It is a question which you ask at the time when such exploitation takes place. In this particular case, of course, it has taken place. So there we have a reference to the artistic work being exploited by A, the making by an industrial process of articles falling to be treated for the purposes of this part as copies of the work, and then marketing such articles in the UK or elsewhere. And we see there a reference to articles in contrast to the artistic work that's referred to at the beginning of section 52.1. And then the consequence in subsection 2 is that 25 years, and for present purposes, because of that transitional provisions, we were concerned with a period of 15 years, but the section says, and a period of 25 years on, from when such articles are first marketed, the work may be copied by making articles of any description. So articles of any description can be made. And then in subsection 4, it provides that in little a, the Secretary of State may make provision as to the circumstances in which an article is to be regarded for the purposes of this section as being made by an industrial process. And as we've heard, such regulations have been made, and the answer is that if more than 50 copies are made, that's to be regarded as an industrial process, made by an industrial process. And then B is the important one for present purposes. He can exclude from the operation of this section such articles, and when it says articles, it's plainly referring back to the articles in 52.1, not to the artistic work itself, but to the articles of a primary literary or artistic character. And regulations have been made to deal with that too, which we find at tab 3 in the bundle. At the bottom, the regulation we're concerned with is the one at the bottom, 3. There are excluded from the operation of section 52 of the Act, so that echoes the words in section 52.4b, excluding from the operation of this section. There are excluded from the operation of section 52 of the Act works of sculpture. So the question is, are the articles in section 52.1a works of sculpture? If they're works of sculpture, then they are excluded from the operation of section 52, and section 52 does not begin to bite. We say the toys plainly were not sculptures, and therefore section 52 does begin to bite. My learned friend raises a question about the additional words in little a, which I'll come to in a moment, if I may, but just let me go a little bit deeper into the way section paragraph 3.1a works by looking at 3.1b and considering, for the sake of argument, medallions. Medallions are evidently something which were considered by the Secretary of State to be of a primarily artistic character, otherwise he couldn't have listed them in this rule. And what he's saying is that if somebody has an artistic drawing of a medallion, referred to in section 52.1, an artistic work depicting a design for a medallion, if he then makes 51 of those medallions, he has manufactured those medallions by an industrial process, according to the definition contained in the rules. Potentially, therefore, those 51 medallions will bring Section 52 into effect. But because by paragraph 3.1b of the rules, medallions are exempted from bringing it into effect, those medallions will not, in fact, spring Section 52, and the copyright owner's copyright will continue unscathed, and he will be able to sue infringers who make those medallions as if Section 52 didn't exist. The same goes for sculptures. If the plaintiffs had confined their merchandising activities to the manufacture of sculptures, then Section 52 would not have had any impact. But because they made those toys, which I would say are plainly not sculptures, Section 52 is not excluded. And then we'd come to look at those extra words and ask whether they make any difference. My submission, in a nutshell, is that they are, if anything, incorporated there by mistake. Because if when one analyses it, the works of sculpture in 3.1a are the 51 works of sculpture which have been made by an industrial process and which potentially spring Section 52 into effect. So we've got 51 works of sculpture referred to in 3.1a, but it then says, other than casts or models used or intended to be used as models or patterns to be multiplied by any industrial process. So what it's referring to is an almost certainly non-existent class of things, the 51 sculptures which are themselves intended or used or intended to be used as models or patterns to be themselves multiplied 51 times. Those words were in fact incorporated in the 1949 designs regulations, where they may have made a bit more sense. But they don't really make any sense here. They don't do any harm, because it's extremely unlikely that there would be any things of that kind. I suppose one might possibly conceive of a hypothetical manufacturer of busts of Beethoven who decides to have a franchise operation throughout the UK, supplying his franchisees with a model bust of Beethoven, which they can then reproduce and supply to their customers. Those busts of Beethoven would be excluded from the exclusion because they were intended to be multiplied by an industrial process. But apart from that ridiculously hypothetical situation, those words in paragraph 3.1a don't make any difference. The only question is, are the works sculptures? So my first answer to Malone Friend's point yesterday...
The model may be destroyed in the process. You get processes where you use the model and it's destroyed in the process of making the final product.
It still would be patterns being multiplied by an industrial process.
That's why you have so many models.
So, Lords, that's my first answer to the point Malone Friend made, that Section 52 is, so to speak, contaminated by the King Features doctrine. It's not. There is buried deep within paragraph 3.1a some unnecessary and probably accidental words that make no difference to the operation of Section 52 at all, and certainly don't contaminate it with the problem which might otherwise have been created by King Features. My second answer is one of fact. My learned friend started his submissions from a somewhat shaky basis in the judgment of Mr. Justice Mann at the core bundle, page 294. His proposition was that at the time Mr. Macquarie's drawings were prepared, there was no intention on the part of the draftsman that the drawings should be used for merchandising purposes. They were also intended to be used for the masks, that's why they were prepared. But there was no intention that they should be used for merchandising purposes. That's his point. And if he's right about Section 52 being contaminated by the King Features doctrine, then the point matters. But he has to establish a factual point first, which he relies entirely on paragraph 185 of Mr. Justice Mann's judgment, which we find at page 295 of the bundle, core bundle. What had happened, or rather what this part of the judgment is concerned with, was Mr. Ainsworth's contention that the work he put in to the development of the products had resulted in an independent copyright. It was still a copyright that was controlled, so to speak, by the claimant's copyrights, but he said he'd put his own work into the products and he had an independent copyright, if not in the UK, at least elsewhere. And those copyrights were potentially valuable to him because he might have been able to say that he was entitled to a slice of the merchandising income. The issue, therefore, was whether he was in fact entitled to such copyrights if they existed. And the learned judge, following the decision in the Robin Ray case, which set out a number of criteria for deciding how such issues were to be decided, in paragraph 185 made some findings. And the one at the top of page 295, which my only friend relies on, is this: I do not consider that at the time the prospect of exploitation via future licensing was in the minds of both parties, and particularly Mr. Ainsworth. And then he does go on to say, because no one anticipated the success of the film, and licensing activities were not then what they've since become. And my learned friend relies on that for the proposition that it wasn't until the film became such a success that there was any notion of merchandising. Well, I say it's a shaky foundation because what the learned judge was concerned to investigate was whether both parties were aware of that, because that's what was relevant for the purposes of the point he was considering. What he didn't remind himself of at that point, and he didn't really need to, was the claimant's pleadings. And if your lordships would turn back to the reply, which you'll find at page 208 in the bundle. At the top of page 17, alternatively, it was an implied term of such agreements that Star Wars Productions was licensed under any relevant copyright owned by Mr. Ainsworth to exploit the said costume designs in connection with the exploitation of the motion picture being made, including the exploitation by merchandising and similar activities, including the manufacture and use of further costumes the same design for use in sequels, such a license being irrevocable. Such a term is to be implied to give business efficacy to the contract and or because it represented the obvious, if unexpressed, intention of the parties. So that was their view of the matter, though, as it turned out, it wasn't Mr. Ainsworth's. But it wasn't only the pleading, which I suppose the judge might have been justified in rejecting. They also put in evidence on this specific point, and that your lordships will find in the new bundle 6 at tab 13. Mr. Rothman was a copyright lawyer and also vice president of Lucasfilm and had been held the position of president of Lucas Marketing since 1986. Been employed for over 25 years. And what he says in paragraph 5 is this: Lucasfilm understood the significance of merchandising rights early on. In the mid-1970s, merchandising was not as prevalent as it is today, but it was still a valuable right to have, and Lucasfilm intended to exploit those rights. However, as a result of negotiation for the financing of Star Wars, Lucasfilm wasn't able to retain the merchandising rights. Fox, the studio financing the movie, insisted on being granted the exclusive merchandising rights for NH. Merchandising at the time was generally seen by the studio as a means of trying to get extra promotion for their movies. The idea was that merchandising would help to promote a movie. With the intended result of the movie being shown in more cinemas, thereby increasing box office returns. Merchandising rights were, of course, important to Lucasfilm, but Lucas felt it was more significant at that point in time to retain the sequel rights as part of negotiations with Fox, which it did. At the time of the negotiations for the financing of the first sequel, Lucasfilm got back the merchandising rights. So, my lords, we say, as a matter of fact, the point my learned friend seeks to derive from the judgment of Mr. Justice Mann is just wrong. Lucasfilm knew perfectly well and had every intention of using these designs for merchandising purposes right from the start. But as I say, as a matter of law, the point doesn't matter anyway, because it doesn't in fact contaminate Section 52. The point that does, however, arise under Section 52, and I think I should deal with it, though my learned friend didn't, is this. If we go back to Section 52 in tab 1, bundle 1, tab 8, we've been looking at 4b. The Secretary of State may by order make provision, excluding from the operation of this section such articles of a primary literary or artistic character as he thinks fit. And that plainly relates back to the reference to articles in Section 52, 1a and b. The question is whether it also relates back to the articles referred to in 52.2. Because Section 52.2 says, after the end of the period of 25 years from the end of the calendar year in which such articles are first marketed, that's the ones in 1a, the work may be copied by making articles of any description, or doing anything for purposes of making articles of any description. And the question is, does articles of any description include products which are in fact sculptures, or does it not? I say that the reference in 4 to excluding from the operation of this section such articles of a primary literary character as he thinks fit refers to the articles that bring the section into operation, that is to say, the articles referred to in Section 52.1a. It does not limit the articles of any description referred to in 52.2. So that, so long as the articles which bring the section into operation in 52.1a are not sculptures, it doesn't matter what the articles in 52.2 may be. They can be articles of any description, including, I would say, sculptures, in the, I hope, unlikely event that your lordships ultimately conclude that these helmets are sculptures. So that brings me, lords, to the main point. Are these things sculptures? And although your lordships seen the object carefully posed on a plinth and arranged as if it were a bust, it is, I think, important that your lordships should see the actual object and hold it in your hands to appreciate the submissions I'm going to make about what it is. And can I pass your lordships one? I think it was made last night, or at all events it was about to be dispatched last night. I was going to bring along my own, but it's broken somewhat from having been crushed in the car boot. It's a pity, because it's the only fee I've got so far for this case. it will fit on your lordship's head. That's one of my points. Yes. That is indeed one of its functions. I'll be coming to that. Also, given my learned friend's concession that he doesn't have any particular difficulty with Mr. Justice Mann's criteria, it becomes of the utmost importance to examine one particular feature of his criteria, that is to say, the issue of function or functionality in the context of copyright works. And it's necessary to do so in two ways, both in general, what sort of functions affect the issue of sculpture or not sculpture, and in the context of this particular case, because my learned friend has a very special point about function in this case. He seems to be saying, if I understand the argument correctly, that things which might have a function in real life, like a table or a car or a revolver strapped to a cowboy's waist, cease to be objects of that nature if they are incorporated in a film, because their only significance when incorporated in a film is a visual significance, and their function, which they might have had in real life, has no function but to appear to be that thing on the film. Therefore, he says, things that appear in films, props on the stage, are something special. They are all sculptures because they have nothing but visual significance. I may have misunderstood the argument, but that, as I understood it, was the argument he was putting. And that's a special point about props in films, and I will deal with that separately.
I thought he said only if they were original works.
He did make the exception about originality, and jumping ahead very quickly to hit that one on the head. In the context of three-dimensional works, originality is a vanishingly small way of excluding things from protection. You can see that from the very nature of busts. The whole point of a bust is that it should be as close as possible to the model from which it's made. The client would be rather unhappy if it wasn't. It's the skill of the sculptor in making something similar, or indeed identical to the model, that confers originality upon it. He does a lot of work, even making a papier-mâché model of a World War II helmet, to use the example my learned friend gave. Somebody has to do a great deal of skillful work modelling that papier-mâché model to exactly the same shape as the original. That is the sort of originality which in the law of copyright confers copyright on a work. Of course, if he took a moulding off the hat, then that might not be original. That would be simply using what is there. That's analogous to tracing, the non-original activity that was referred to by Lord Justice Oliver in the Interlego case. That's analogous to tracing. But once somebody uses his skillful hands to make a copy, he is conferring originality on what he does. So that exception of originality is vanishingly small. And in any event, it would be unusual for props to be that close to any prior art. They would almost certainly not be copied from prior art anyway. They might be very similar to prior art, but that doesn't affect copyright. That's a point perhaps I should make good. It's a conventional point in copyright law. it's the skill and labour of creating something which confers copyright, despite the fact that what you make might be identical to something which somebody else had already made. The conventional example is a set of log tables. Somebody does a lot of work compiling a set of log tables. He has copyright in them. He can prevent anybody copying those log tables. But if somebody else does their own calculations and comes up with a set of log tables which will be, for practical purposes, identical, maybe entirely identical, he has his own independent copyright in that set of log tables that he has made. And so it is with film props. There will be originality in any table made by a props man without copying from anybody else's table. However similar it may be to other tables, it won't be lacking originality. So my learned friend's point about originality does not detract significantly from the ambit of the claim he's making for copyright in film props. That, in a sense, was jumping ahead slightly. I want to look first at the question of functionality in general. Mr. Justice Mann, in the criteria which he sets out at page 276 of the core bundle, sorry, it starts on page 275. Although they were described in the learned friend's case as being somewhat question-begging, his concession that he now doesn't have any great quarrel with them does make, I think, my task slightly easier than it was. But it's nevertheless worth looking at them. Some regard has to be had to the normal use of the word sculpture. I would say that's self-evidently right. More question-begging. Nevertheless, the concept can be applicable to things going beyond what one would normally expect to be art, in the sense of the sort of things that one would expect to find in art galleries. Fine. Of course, sculpture these days is not only found in art galleries. It doesn't follow that one should ignore the place where things are on display. That's a factor which might, to some extent, affect the issue of whether something's to be regarded as a sculpture. A pile of bricks on the floor of the Tate, is more likely to be a sculpture than a pile of bricks at the end of Mr. Justice Mann's drive, as he himself pointed out. It's inappropriate to stray too far from what would normally be regarded as sculpture, a point which is entirely in accordance with the earlier authorities which Your Lordship was referred to yesterday. No judgment is to be made about artistic worth. Not every three-dimensional representation of a concept can be regarded as a sculpture. Otherwise, every three-dimensional construction or fabrication would be a sculpture, and that cannot be right. Well, my learned friend accepts that too. It is of the essence of a sculpture that it should have as part of its purpose a visual appeal in the sense that it might be enjoyed for that purpose alone, whether or not it might have another purpose as well. The purpose is that of the creator, which reflects the reference to artist's hand in the judgment of Mr. Justice Laddie, with which he agrees. An artist in the realm of the visual art creates something because it has visual appeal, which he wishes to be enjoyed as such. He may fail, but that doesn't matter. It's the underlying purpose that is important. And then we come on to, if you like, a qualification of what he's just said. The fact that the object has some other use doesn't necessarily disqualify it from being a sculpture, but it still has to have the intrinsic quality of being intended to be enjoyed as a visual thing. Thus, the model soldier in Britain might be played with, but it still apparently had strong, purely visual appeal, which might be enjoyed as such. Similarly, the critters in Wildash had other functions, but they still had strong, purely visual appeal. It explains why the frisbee itself should be excluded, and so on. And, Lords, it's this aspect of function which I think is important in this case, and which I should address. It's with particular reference to the registered design system. It's always been commonplace to embellish functional objects with things which on their own might be said to be sculptures. But in the great majority of cases, the embellished objects would not be described as sculptures. For example, an apostle spoon, a richly decorated Paul de Lamery silver wine server, a Toby jug. There are a very few exceptional items where the function is so subservient to the sculpture that most people would still regard the object as a sculpture, such as the Trevi fountain, to use an example my learned friend mentions, or the Cellini salt cellar, which is exhibited to or illustrated in our case. Maybe the candlesticks in the Australian wild ash case, though the judge's alternative finding that they were works of artistic craftsmanship seems to me slightly more convincing. The important point, I would say, is that it is only in rare cases that one can say that the function is so subservient to the visual appeal that any ordinary person would describe the object in question as a sculpture rather than a spoon, a wine cooler, a Toby jug, a toy, or what have you. This is not a question of the quality of the artwork. It's simply that in the vast majority of cases, the artwork and the function are of comparable significance. The Toby jug, for example, which has very prominent artwork, but few, if any, would describe it as a sculpture, and I would submit it plainly isn't a sculpture within the meaning of the act. So,
At some stage in this case, someone must surely look around this courtroom and start to analyse the various carved features.
the vulgar embellishments of the roof.
The embellishments above the door up to the angels in the ceiling, or the carving on the edge of the chairs of the...
Before your lordships came in, I said that we ought to have a party line on that on my side, but I'll have to answer the question without the benefit of...
But basically, you're saying that whereas this assumption says the test is one of predominance, or what is the primary, how you make an overall judgment, you say the test is really, the needle is in another direction, and unless you can say the sculptural aspect is overwhelming, it isn't sculpture.
Yes, yes.
It's just artistic craftsmanship or
Indeed.
design.
Yes, yes. And one sees it all the time, in particularly Victorian artworks, or Victorian craft work, Victorian design work, the sort of things that were on display at the Great Exhibition in 1851. Hugely intricate design work applied to ordinary household items. That, in my submission, was the proper place for the registered design system. Sculpture was to be confined to that which was overwhelmingly of visual significance.
How about picture frames? Just looking at these frames. Pictures don't need to have a frame at all. It's not...
Well,
it's something that is an artistic enhancement very often of the work of art.
Lord, I would say that they have, well, firstly, I would say very few people would describe a picture frame as a sculpture, though occasionally one might possibly encounter an extremely elaborate
Grinling Gibbons.
If you've been in Court 3 in this building,
No, I haven't.
you will see a remarkable picture frame there.
I think there could possibly be instances, but I would submit probably vanishingly few. Even those cases, I would say, were works of artistic craftsmanship. Undoubtedly craftsmanship, and probably artistic craftsmanship too. But they have a function, which is to frame a picture. They are possibly looked at with approval, but they do not overwhelm the function of framing the picture by being themselves so visually significant that one ignores the picture within them. So this, if you like, is an instance where the function is a visual function of a sort, because the frame is a visual thing, but it is a function which detracts from it being a sculpture. That frame up there, its primary function is to frame the picture. It is an object which is purely visual in the learned friend's sense, but I would submit no one would describe that as a sculpture. It's a picture frame.
You might describe that frame up there as having sculptural qualities, but you would
yes.
say it's not a piece of sculpture.
Absolutely. One has to differentiate between sculptural properties and sculptures for very evident reasons when one comes to think of all sorts of industrial designs which have sculptural properties. The Toby jug has sculptural properties. In fact, if one takes it to its limit, just about every, and moving beyond sculptural properties to the verb sculpt, one of the problems we saw ourselves as being faced with at an early stage in this case was that just about everything is sculpted in this sense, that every plastic object, every glass object is made from a mould which has been produced by a process of sculpting by a highly skilled craftsman. Yet no one would describe that jug as a work of sculpture. So the mere fact that something is sculpted or has sculptural properties, in the sense of having been carved, is certainly not enough to make it a sculpture.
If it's an integral part of something,
Yes.
does one consider the whole, or can one consider the part? I was thinking, for instance, of a walking stick with a carved head.
Lord, I would say that was a walking stick with a carved head. It is not. It may be a work of artistic craftsmanship, and the work that went into the carving of the head undoubtedly makes it a work of artistic craftsmanship. The sort of point your Lordship's putting to me raises a point I was going to deal with in a moment, but I'll jump to it, and that is that the functions associated with sculptural bits may play different roles in the composite object. In the case of a Toby jug, it's the actual shape of the jug, the sculptural shape of it, which is also that which holds the liquid. So in that case, you could say the whole function is engaged on enclosing the liquid. In other cases, the functional part may be slightly more detached in the sense of the knob at the top of the walking stick, though the knob at the top of the walking stick still has the function of being held by the hand as the walking stick is used. The handles on a highly decorated piece of vulgar French furniture could be regarded as sculptural in themselves, but you wouldn't say that that furniture was sculpture. It's a piece of furniture. And the same go for the highly carved legs of a chair. Work of artistic craftsmanship, almost certainly, but not, anyone would normally say, a sculpture.
What is the function of the helmet and armour? Is it to make the wearer look like an automaton?
There are two. I'm going to deal with that. That's a point I want to deal with in considerable depth, if I may. I don't want to jump ahead on that one. I'll get to that in a moment. I'm not ducking the issue. It's obviously hugely important here. So there are. Sorry. There are other functions which have been discussed in court. One is the question of the veneration of a religious statue, and the question was raised, would something cease to be a sculpture merely because it's venerated as a religious statue? Well, that, I would submit, is plainly not the sort of function that would deprive a work of its status as a sculpture. Veneration is just one of the ways of making use of a visual object comparable to the contemplation of it. No one would reasonably suggest that a sculpture, which is the object of veneration, which itself consists largely of looking at it, thereby ceases to be a sculpture.
We're getting into Greek philosophy here, aren't we? And we're looking for the essence of things.
Possibly. I want to get on to the practical point about that, but I just wanted to deal with that veneration point, because what's suggested is that because a sculpture in a niche doesn't cease to be a sculpture because it's venerated, for the same reason, an object seen in a film doesn't cease to be a sculpture because people enjoy the film. That seems to be the sort of argument that's presented. I would say that the fact that something plays a role in a film, well, I'll come to the significance of films in a moment. I just wanted to get that point out of the way, and it's a short point, and I've got it out of the way. More importantly, is the point about playing with toys. Because my learned friend relied on an indication in an American case that the fact that you're playing with toys doesn't mean that the object is to be regarded as a functional object, as if that taught us something about the nature of play in the context of sculpture. He was, I think, seeking to say that the fact that things are played with doesn't have any effect on their status as a sculpture. And I would submit that that's wrong. The function of playing with a toy is as much a function as the function of holding a walking stick by its handle. It may be that in some cases a toy has such overwhelming visual significance that its function as a toy is overwhelmed, and that must, I think, have been the case in the Britain case. But in the ordinary way, a dinky toy, for example, has the function of being played with. On my learned friend's analysis, every dinky toy would in fact be a sculpture. Let me just examine that. My learned friend says an E-type jag is not a sculpture because it has a function. He accepts that's not a sculpture. It has a function. It's a car, a means of transport, and therefore everybody would say its function is its predominant one on my learned friend's analysis. It is not a sculpture. But a dinky toy, he must say, is a sculpture. The fact that it's played with is not a function which is relevant for present purposes. It has no other function. It has visual appeal because it's a copy of an E-type jag. And assuming it also has originality because somebody's had to do quite a lot of work getting it right, on my learned friend's analysis, the dinky toy of an E-type jag is a sculpture. And I would submit that that can't be right, and it casts doubt on my learned friend's basic propositions. It does have eye appeal. It is 3D. It has, on my learned friend's analysis, no function. And then there's the dinky model of Lady Penelope's Rolls-Royce, which we exhibited to our case. But the same considerations would apply to that on the learned friend's analysis.
Or the model railway. You would
Model
say,
railway, yeah.
You would say that has a function.
It does indeed, of being played with. And of running round its tracks as well, perhaps. So
well, if one thinks of the scornful reference to dolls
yes.
In the toy soldiers case,
Yeah.
I think that's Britain, isn't it? There are some dolls that are actually made to be looked at and not to be played with.
I wouldn't
to
have
be collected and put in a glass case,
that.
maybe even venerated.
Yes,
And there are other dolls that are made to be played with.
exactly, lady. I would say that illustrates the dividing line which I say exists between that which is a sculpture, because I think such a doll might be a sculpture, and that where the function overwhelms its sculptural qualities.
The child who won't go to bed without a doll is certainly not interested in looking at it at night.
No, quite. But it undoubtedly has an appearance, it has 3D appeal, but it can't be right that play is to be discounted the fact that something to be played with is to be discounted in the assessment of whether it's a sculpture. My only friend got the point from American cases. American cases are very different from English cases, and I'll be dealing with that in more detail, particularly in the context of the justiciability point. But there is a fundamental principle in American law which simply doesn't exist in English law, that which is functional cannot be protected by copyright. It stems from a case called Baker and Selden in the 19th century, and it's now written in to the American statute. And whilst it sounds like a common sense principle, as we shall see when we look at the cases, it has been applied in some, what we would see as rather extraordinary ways. In particular, it has been said that all clothing is to be regarded as functional within the meaning of that doctrine. And that's why, an issue was whether something which was a toy was to be condemned also by that doctrine as having no copyright attaching to it. And on that point, it was considered that the fact that it was a toy didn't condemn it under the American functionality doctrine. But that is a completely different question from the sort of questions we're considering here. And my submission is that the function of something as a toy is as much a relevant function for deciding whether something is a sculpture as any of the other functions which one sees with a Toby jug or a wine cooler or an apostle spoon and so on. So, my approach to functionality is that it's not enough that visual appeal should be the predominant aspect of an object. It is that functionality almost always makes something not a sculpture unless it's wholly subservient to the artistic visual impact, like the little salt pot, which I suppose is hidden somewhere in Cellini's salt cellar, or the fact that horses sometimes sup at the Trevi fountain. And to emphasise, I hope that I'm right about that, can I take your lordships to the Gregory report in bundle 2 at tab 3. The Gregory report preceded the 1956 Copyright Act and postceded the 1949 Registered Designs Act. And in a passage at paragraph 262, the committee considered issues not dissimilar to the sort of issues we're concerned with here. And in particular, the special problems of toy soldiers and other models.
I'm sorry, I seem to have lost the reference.
Tab 3, bundle 2. turning a page from the cover, special problems, toy soldiers and other models. It's been represented to us that manufacturers of toy soldiers and similar toys should enjoy the protection of the Copyright Act. The toys here referred to are those in which a statue or prototype is modelled, for example, as a faithful copy of a soldier of a particular period and regiment. This model is then used to produce lead or other casts in quantity, the casts being usually painted subsequently or otherwise decorated. Manufacturers spend time and money on the careful production of the original statue or prototype, only to find that competitors may use their resulting toys once they're put on the market as casts for the production of cheap copies. Such piracy was not possible, we've been told, under the old law prior to 1911. Presumably that's a reference to the Britain case. Under the present law, section 22 and the Designs Rule 26, that, your lordships will find at tab 26 of volume 1, that was the one that exempted sculptures from registration and brought them back into the realm of copyright protection. So the committee and toy manufacturers were under the impression that even though sculpture had been, or rather sculptural mass-produced products had been restored to their proper position in the Copyright Act by the 1949 Registered Designs Act, nevertheless, toys so made are not protected by the Copyright Act. Also, the designs cannot apparently be registered, at least when they're faithful copies, because then they're not novel. The recommendations we've made above do not materially help the toy manufacturer in these respects. Certainly, copyright protection won't be ruled out ab initio, as under the present law, by the mere not be ruled out ab initio, as under the present law, by the mere intention of the designer. We've seen that from the effect of the King case, Popeye case. But this protection will cease once the industrial multiplication of the toys is started. And just explaining that remark, what they recommended and what was in fact adopted in the 1956 Act was that the Popeye principle should be abolished, and in its place should be established a regime where if something was a registrable design, then it didn't get copyright protection. So it says, and in addition to that, there's the point that once something is industrially produced, it loses its copyright protection. At that stage, the design must be registered if it's to be protected at all, and this will only be possible if the design is novel. Note in this connection paragraph 309 and 310 of the final report of the Departmental Committee on Patents. But then perhaps I can go a bit further down. Similarly, toy manufacturers have suggested to us that if the Copyright Act is not to apply to registrable designs for industrial multiplication, then designs for these toys should be made non-registrable by amending Designs Rule 26 to delete the words other than casts or models used or intended to be used as models or patterns. That is, to exclude from registration all works of sculpture, including such casts or models. We felt sympathy with the toy manufacturers. Their predicament is largely due to the fact that they desire to manufacture goods which are faithful reproductions, and thus, although industrial products, are not new in design and cannot be protected under the relevant law, Registered Designs Act. However, we do not recommend that the suggestion of the toy manufacturers should be adopted. It seems to us that a work of sculpture or modelling, when copies of it are multiplied by industrial processes, may serve varied utilitarian purposes, not merely as a toy, but alternatively, for example, as a doorstop, or if hollow, as a bottle or container, or if provided with a lamp socket, as a lamp holder. For such manufacture, we think that any protection for the design or appearance should be through the Registered Designs Act. So what they're clearly saying in that sentence is that you can have a sculpture, or things which people would normally regard as a sculpture, but when it is employed as a toy or a doorstop or a bottle or a lamp socket or a lamp holder, then it is not to be regarded as a sculpture. And that approach to it, in my submission, is consistent with the definition I put forward of a sculpture. And what's more, it makes sense of the Registered Designs Act. Because if my learned friend is right, and all sorts of things fall within his extensive definition of what constitutes a sculpture, then all sorts of things will not be registrable as designs. So, Lord, I think the moment has come. Sorry, yes. I should have said in referring to Mr. Justice Mann's criteria that I say that his criteria were absolutely right in what he said about function, though I would perhaps put it a little higher than he did, so far as the effect of function on converting something from, or rather preventing something being a sculpture is concerned. So, Lord, I think the time's come to look at the product we're concerned with here, and to say, as an initial remark, that this product is a registrable design par excellence. It's a costume. It's an industrially produced costume. It has the function of being a costume. Now, the claimants have two answers to that, as I understand it. The first one is that even if it has a function at all, the appearance predominates. And secondly, he says it doesn't have any function at all anyway, because of his special rule which applies to film props. Let me deal with the first point first. Because I think I've already dealt with it in my general submissions. I say that it is not a question of the appearance merely predominating. It must overwhelm such residual function as exists, which it'll probably only be capable of doing when it is what you might call fine art. Whatever its merit, it's more a question of intention whether something's fine art. If you have a costume or a dress, something of that nature, however beautiful, a dress or a costume is not a sculpture. Its appearance may be the predominating feature of a dress, but it is still not a sculpture because it doesn't overwhelm the function of being worn. It may be a work of artistic craftsmanship, but that's a different matter. And so it is with these costumes. Their costume, I'll come to all their other functions as well, but their function as a costume in itself is enough, I would say, to make it quite plain these are not sculptures. And then his second point about film props. If I understand the point correctly, what he says is that sculpture is something which is predominantly or exclusively visually significant in 3D. You can't take into account, he says, the process of manufacture or the manner of display, which is why his statement of what constitutes a sculpture is so simple. Though, before going on with the argument, I would dispute that last proposition. It contradicts Mr. Justice Mann's indicia. The manner of display is an indicium. It's not conclusive at all, but it is an indicium, and so is the way something's made. Again, not conclusive, but nevertheless an indicium. If that object there had been made by somebody with a hammer and chisel and was sitting on a plinth in the marketplace in some Star Wars planet, it may be that one could legitimately describe it as a sculpture. But the way it is in fact made, with a number of pieces of plastic made from that white stuff there by a process of vacuum forming, and if you look at the hat, the helmet, you can see it's a number of individual components bolted together with rather rough and ready bolts, which stick out on the inside. That, whilst not conclusive, is an indicium that it's not a sculpture. So I don't agree with my learned friend's fundamental point that you can ignore processes of manufacture or where something is intended to be displayed. They're relevant, though by no means conclusive. But anyway, his argument continues. Since a film's only significance is to be seen, and I suppose heard, the only function of anything seen on screen is to be seen, therefore those functions have nothing but visual significance, and therefore they must be discounted as functions for the purposes of saying something is not a sculpture, or to put it another way, they are to be seen as part of the visual significance which turns something into a sculpture, unless it fails the vanishing originality point. This is a fairly remarkable submission. It creates a whole new world of sculpture. Every object, whatever, in the real world has a sculptural equivalent when it's a film prop. Take the tables in Mr. Macquarie's original drawings, which you'll find at core bundle page 384. You'll see some tables there, rather rough and ready tables, a stool on its side, on the right-hand side, and some pots and pans and so on. The learned friend says that when the props man gets to make that table, its only significance is to be seen in the film. It is therefore a sculpture.
I don't say that.
Oh, he says he doesn't say that. I must confess I'd understood him to be saying just that. But if that's not what's said, then I'll continue my submissions with the qualification that that's not what's being said. As I understood it, he was saying that everything shown in a film has nothing but visual significance. To which I would submit that that proposition is simply wrong in law. If the man in the street looks at a car in the street and says that is not a sculpture, he will look at an imaginary car in a film and say, that is not a sculpture. As a matter of law, in my submission, props in films get the same treatment when asked, or when one asks if they're sculptures, as corresponding objects in the real world. If that thing was sitting on a plinth in a marketplace, or sitting on Darth Vader's desk in his study, one might say, seeing it in the film, that's a bust, it's a sculpture. But if, on the other hand, it is being worn as it was as a costume, one says that's a spaceman's outfit. It's not a sculpture. That's what you'd say if you saw a spaceman walking down the street, you'd say he's wearing a spaceman's outfit. When you see television films of American spacemen landing on the moon, they're not wearing sculptures, they're wearing spacesuits. And that's what the soldiers in Star Wars are wearing, spacesuits, costumes. And nobody seeing the film would say they're wearing sculptures. The mere fact that they're in a film does not, in my submission, as a matter of law, make any difference to their status as sculptures or not sculptures. Take an example. A cowboy film. A shot of the cowboy viewed from the front. He never needs to be looked at from the back, so the holster with his gun on it doesn't actually hold his trousers up. It's just pinned at the back by the props lady and doesn't serve the function of a belt. Its only significance is visual significance. The gun in the holster doesn't come out and can't be fired. Its only significance is visual significance. But the learned friend, as I understood his argument, would be saying that those things are sculptures because they're of visual significance only. They have no true function other than being seen and appreciated on the film.
Well, he did also say it had to be original, but he may have been using original in a sense which you don't accept.
My Lord, two answers to that. One is that the originality point is vanishingly small, as I've already said. But secondly, the cowboy's belt might well be original in the sense that it's got studding on it which nobody's ever had before in those positions. So one could well assume that the cowboy's belt was an original belt, but it would not be a sculpture. Anybody looking at it, anybody approaching that with a normal attitude to what constitutes sculpture, would say, in that film, I saw a cowboy wearing a belt, a decorative belt, an attractive belt, but he wasn't prancing around in a sculpture. So, if I'm right about that, all these functions on the of the spacesuit, the flexible limbs, the breathing tubes that you see coming down the side of them. You see the breathing tubes coming down to the front, the way the eyes are depicted, the nose, if it is a nose, or I'm not quite sure what it is, but the holes there, grill. All those things are, in a sense, functions. They're pretend functions, because they don't actually function as breathing tubes, any more than the gun which doesn't come over the holster functions as a gun. But they are things which would be appreciated by the viewer as the pretend functions of the object in a film. And I say that the pretend functions of an object in a film are as much functions for the purposes of deciding whether something is a sculpture as the genuine functions of the corresponding object out of the film.
Is it wrong to describe your case as being that the function is to make the viewer think of a robot, or make the viewer think he or she is seeing a robot? Is that a function? Or is that...
That, one might say, was purely visual. The function...
Yes.
Let me take it in stages.
What is it then?
Suppose you had a car on the street.
Yes.
That car has the function of being a transport facility, and everybody knows that things with that function are not sculptures.
Yes.
No one would call a car a sculpture.
Yes.
Now, a car in a film has the pretend function of being a transport facility. It may not have an engine in it. It may indeed only be the side of the car that faces the camera. But anybody looking at it would say that is a transport facility. It's a pretend transport facility used in the film, but it's a car. It's not a sculpture.
Isn't that what I was saying? Then the function is the pretend function
Well,
of being
yes,
a robot.
Yes, it's not the function of making somebody think this is a robot.
No.
It's more a question of when the person sees it, he says to himself, that is not a sculpture, that is a car. It's a pretend car. But the function is not to make him think it's a car. The function is, if you like, a filmic equivalent of the transport function. It's an unreal function because it can't actually perform it. But if you said that the filmic equivalent of real functions don't count, then you get to the absurd position that everything in a film has no function and is therefore, on the Learned Friends analysis, a sculpture. So I say that the filmic pretend functions of the gun of the imitation gun at the cowboy's waist is as much a function for the purposes of determining whether something is a sculpture as a real function. And the reason for that is common sense, if you like. Sculpture is what people perceive as sculpture. But I think that's perhaps a rather overgeneral simplification, but it's got a good deal, it's a pretty big indication. And no reasonable person would see an imitation car in a film as a sculpture. And the reason they wouldn't is because they'd be saying, that's a car, I know cars aren't sculptures. If he sees a gun, an imitation gun, he'd say, that's an imitation gun and I know guns aren't sculptures. If he sees a spacesuit, he says, that's a spacesuit and I know spacesuits aren't sculptures. When he sees that thing being worn by 50 stormtroopers charging through a spaceship, he says they're all wearing uniforms. He doesn't say they're in sculptures. So that they're wearing the right costumes for the function they're performing. They're soldiers performing in a vacuum or possibly an atmosphere which is toxic to them. They're wearing a uniform which is appropriate to that kind of place where they're fighting. But what they're wearing is just a prop, a costume, suitable for use in a film, but certainly not a sculpture. And when you look at the pictures, you can see that's what was intended. In Macquarie's pictures show a costume. They're costume designs. And what was made was costumes, not sculptures. Of course, they have a considerable visual impact, as clothing and as clothing and costumes generally do. And so, for that matter, do many registered designs, so do many purely functional objects, as the illustrations to our case illustrated, those splendid trains. Those have huge visual impact, and possibly even some emotional impact. But they're not sculptures, nor are models of them.
There's a very fine sculpture of a train just outside Darlington.
There are some sculptures of trains. I wouldn't.
Which you would call a sculpture.
I would, exactly. Just outside your lordship's court, there's a statue of Abraham Lincoln with a chair behind him, a bronze chair. That's a sculpture of a chair. But if a similar chair was made for use in a film and Abraham Lincoln was standing up and sitting down on it, that chair would not be a sculpture.
But if it's used or can be used for functional purpose in a film,
Yeah.
it is different from something which in fact cannot be used for such purpose and is simply an impersonation. I think you're saying that if it's an impersonation of something that is functional, it's to be treated as if it were functional.
Yes, that is one of my submissions. That is indeed one of my submissions. That if you like, it's a function in itself to appear to be the thing that has that function, which is perhaps the submission that
I think that's what my lord was putting to you, which you wouldn't accept.
Yes, I think
you would say the function of the imitation car is to drive along the road,
yeah.
and it's just the fact that it's pretending to have that function rather than really having it is irrelevant.
Yes, yes. Now, it's perhaps a philosophical question whether you put that in terms of whether it's intention or whether the function is to make somebody think that, or the function is to be that, and that is perhaps dancing around on the head of a pin. But that's my first submission, that my learned friend's analysis of the significance of the fact that things appear in films is wrong in law. And if I'm right about that, then what Mr. Justice Mann and then the Court of Appeal said was absolutely right, and even if you might come to a different view of the balance between the visual appearance and its function, it wouldn't be for you to interfere with the decision that had already been made. So that's my first point, that what my learned friend says is simply wrong in law, that its various pretend functions as a space suit, although it's not a real space suit, its pretend function as a space suit means that it should be treated in relation to the law of sculptures in just the same way as a real space suit will be treated in relation to the law of sculptures. My next point is that my learned friend's point is wrong in fact as well, because even leaving aside the pretend functions of being a space suit, the breathing tubes at the side, the fake ammunition pouches that were built into it, not real ones, of course, but even leaving aside all those aspects of it, there was another class of functions which this object had, well, it all boils down to one really, which was a real function, not a simulated function. It had the real function of performing as a costume during the making of this film. This is something which you can put on. You can see through the holes. Actually, the specimen I handed up, there's a point to be made on that. It's there again. I say you can see through the holes. Actually, you can only see through the holes if you take out this feature of the deluxe version of the mask. These little fellows here were put in for close-up work. The actual actors, when they were rushing around, wore it without these because you can't see through it. So they wore it like that. You can't see it in the film, but when you see people close up, they've got this little chap stuck in the eyes to make it look more like a...
Scary.
More scary, perhaps, yes. But in the ordinary way, they'd be running around like this. But that serves perhaps to emphasise the function of this thing as a costume.
The stormtroopers in the film were intended to be portrayed as living bodies inside these, or were they intended to be portrayed as being those very things?
I think they were living bodies within them. That's why it's got this breathing apparatus.
Yes.
Whether they were humans inside is another matter, but they were
flesh and something anyway.
This is armour rather than skin.
Yes. But I think there's a moment in the film when Luke actually puts one on in order to masquerade as a storm.
I'm reminded that's correct.
Stormtrooper.
Right, well, that makes the point that they are indeed they're pretend uniforms, but they're actual costumes. And whatever they look like, their function during the making of the film was to serve as the costumes for the people wearing them. They've got pads to make them more comfortable in the top. They've got holes in the front to breathe through, which would of course ruin it as a thing for use in a vacuum. But they've got these communication devices at the side, which serve the additional function of hiding the seam between the two vacuum-formed units there. It's light enough to be worn. It was actually worn in the desert, and the whole outfit needed, on the one hand, to be somewhat ventilated to let the air come through, but on the other hand, it needed to look as if it was an articulated, fully closed spacesuit. And indeed, in the course of the filming, the suit itself needed to be modified somewhat to make it more comfortable. There's an invoice in the bundles that records that at page 119 of the core bundles, where Mr. Ainsworth invoiced for some modifications he made to the suit. He had to retool certain components to make them more comfortable in the desert.
Is there inherent in your, just going back to your concept of pretend function, is there inherent here some latent distinction which we haven't expressed? I mean, pretend function is a type of visual impact, but are you saying it's a different sort from a properly understood sculptural impact? You're not supposed to, the visual function is not supposed to make you admire it or to have any aesthetic qualities. It's really to make the viewer identify the evil characters and to follow the story. Is that a way you look at it?
But certainly one aspect.
And do you draw that distinction between types of visual impact or the purpose of the visual impact? It's part of the story.
Yes, I do. In a sculpture, the visual impact is intended to be, for the purposes, if you like, of contemplation or some sort of, the sort of purpose that an artist is trying to convey to the viewer of a sculpture. Now, in the old days, it may only have been the contemplation of beauty. It may now include the contemplation of horror, or a shark in a tank of formaldehyde, whatever that conveys. But it's still inviting the viewer to get an appreciation of the object, which is the sort of appreciation that one expects from the contemplation of sculpture.
Is that how you distinguish the robot woman in Metropolis?
Sorry,
the robot woman in Metropolis.
Well, as I saw it, I haven't actually seen the film, but it did look very much to me like the sort of thing one contemplates as a sculpture. I may be wrong about it. It may be that it's actually much more in the same nature as this. In fact, talking about it later, I gather the thing that there's people walking around it and things, yes. and it probably is analogous to this. In which case, it may well be that it's not a sculpture. It was just a costume. But it was, the German court was impressed by the fact that it was designed by a recognised sculptor, who intended it as a sculpture. So frankly, I don't know very much about that product. As I say, I haven't seen the film. But it may or may not be. Certainly, looking at the picture of it, and looking at that, actually, just looking at that, in the absence of what we know about its functions, one might think, well, that's a bust on somebody's desk, suitable for Darth Vader to have, and for artistic contemplation in the privacy of his own study. And indeed, that's very much how it's presented there, for your lordships. But if that's how the statue or robot in Germany was intended to be perceived, then maybe that would be a sculpture. But if, on the other hand, it's just a robot dashing about, like these things, then probably not.
What about the Salvador Dali's designs in Hitchcock's Spellbound? You would say they...
I confess I'm not familiar with those, but they sound as if, well, it's hard to imagine Salvador Dali designing something that people could wear, but...
No, they're sets.
So that is a level bit. What about the Tin Man in The Wizard of Oz?
Probably a work of artistic craftsmanship. but not a sculpture. An outfit, but not a sculpture. But there is perhaps a difference between the Tin Man and the Wizard of Oz and these things. That these things, the Tin Man and the Wizard of Oz was wholly one-off and didn't represent anything else one had ever seen anywhere else. These things are just spacesuits being worn by spacemen. They're futuristic ones that haven't been seen before, but they're not different in kind from the spacesuits worn by American moonwalkers, or for that matter, the diving suits worn by divers. And that's what these things are intended to be.
You can't really distinguish between the straw man and the Tin Man, can you? I mean, as a matter of principle. I mean, you'd say they're both theatrical costumes.
But that was certainly
Although one is looking much more like a real thing, because the straw man is looking much more like a scarecrow than the Tin Man is looking like anything.
Yeah, but I suppose, just trying to get my head around the Tin Man, I think in the end it is just a rather extravagant costume. But one could perhaps conceive of designs which were so far removed from normality and so functionless.
Frankenstein.
Well, Frankenstein was clever makeup, if you like. But it would be difficult to say that it was a sculpture. It was a human being anyway. We did look out a couple of cases on makeup last night, actually, for this particular point. There's a case called Adamant, in which an attempt was made to say there was infringement of copyright in some makeup that a pop star applied to his face. He had some distinctive stripes applied to his face, and eyeshadow, and a little heart above one of his eyes. And it was argued that that was a copyright work in the nature of a painting, which the Court of Appeal had some difficulty with, and the action didn't go any further.
So American law is very different, but one of the cases mentioned in one of the articles says that the makeup in Cats, the stage production, was copyright.
Yes, I was not terribly happy with the result in the Adamant case. I mean, it is possible that you could say that that's a painting of some sort. And the other case we brought along is Shelley Films, in which extremely elaborate makeup was made for a subsequent Frankenstein film. And in order to illustrate the development of the Frankenstein monster, the actor playing the part, I can't remember who it was provided with a number of rubber mouldings that fitted to his face with various development stages of the development of Frankenstein. And the argument was that those could be regarded as either sculptures or works of artistic craftsmanship. And for the purposes of an interlocutory injunction, that argument was accepted. I think probably the arguments have gone a long way beyond that in this case. The notion that they're works of artistic craftsmanship is probably rather closer to the true position, though I suppose they're almost analogous to sculpture because they were a representation of a face by a person who was something in the nature of a sculptor. So those were at least on the borderline. But these, I would submit, are nowhere near the borderline. They are simply spacesuits. They're spacesuit costumes, and they're worn for the purposes of clothing soldiers who are rushing around doing what soldiers do in several millennia's time. Yeah, and the armour's articulated so they can run around.
Similarly, you'd say that the helmet which Siegfried wore, which was supposed to make him appear invisible, was had what function? It had a function of making the viewers think that he was invisible, playing along with the story.
Well, I think it had two functions, actually. That's one of them. The other one is to be a costume, or part of his costume. And as a costume, it might qualify as a work of artistic craftsmanship.
His real function is
pretend function.
It's part of the story, actually.
Yes. Yes, well...
Without it, I mean, the thing would look ridiculous.
Yes.
I suppose it looks ridiculous anyway, since he's supposed to be invisible.
Yes. I'm not sure one can press that too far, because I suppose one could conceive of a sculpture of this invisible man on an empty plinth, which might perhaps be a sculpture, if it worked. But when he's actually acting the part, and it is his costume, then I would submit that that is not a sculpture. At most, it's a work of artistic craftsmanship. The only things I would concede would be sculptures in a film would be the things which people looking at would say, those are sculptures. Looking at that, posed like that on Darth Vader's desk, one might say, that's a sculpture. But prancing around on a soldier, it's a costume. Its intention, both in reality and in the film, is to provide clothing for someone and to be worn. Also, I've laboured this point of function because it's obviously of huge importance in this case. It's right at the centre of
I was wondering that too.
Mr. Justice Mann's criteria. I would say that there was no real difference between what Mr. Justice Mann said and what the Court of Appeal said. The Court of Appeal were elaborating what Mr. Justice Mann was saying was the function and explaining what he said, but they weren't differentiating or diverging from him. Well, can I then move on to some more detailed submissions which I think need to be made about the spectrum of protection provided by the Copyright Act and the Registered Designs Act? Because my learned friend belittles the notion that you can get any assistance from this spectrum, but in my submission it's quite important in trying to understand what's meant by copyright in the context of the Copyright Act, to see it in the complete matrix of protection provided under the 1988 system and indeed earlier systems, because my learned friend and I think, are in agreement that the meaning of the word sculpture hasn't changed over the years. But the first point is to look at the meaning of works of artistic craftsmanship. We say the works of artistic craftsmanship rank lower in the hierarchy of protection than sculpture because they are dealt with less favourably. They're dealt with less favourably in this respect, that in the rules made under Section 52 and its predecessor under the 1949 Act, Rule 26, we've seen how sculpture was exempted from the dire effects of Section 22 in 1949, in the 1949 Registered Designs Act, and how it continued to be exempted from the dire effects of Section 52 in the current legislation. Works of artistic craftsmanship do not have that privilege. Works of artistic craftsmanship, if more than 50 are made and marketed, lose their copyright protection after the relevant period now of 25 years. Now, what sense can there be in the distinction between them? As my learned friend rightly says, it can't be anything to do with aesthetic considerations. Aesthetic considerations, you can have bad sculpture and you can have jolly good industrial designs. You can have sculpture with very little aesthetic impact. You can have a work of artistic craftsmanship with considerable aesthetic impact. What I say is the principled distinction between the two is that works of artistic craftsmanship include products which have a significant function. Sculpture does not include products that have a significant function. Take, for example, dresses, costumes, imitation spacesuits. These have a function, whether it's to be played with, played in, worn, or anything else. That is a function. And that function turns them into a product of what one might call applied art rather than fine art. Sculpture is intended to be a fine art, like painting. And the sculptor is intended to be treated like the painter, as the Gregory report said. But once the product in question has the sort of function that costumes, clothes have, it is no longer a fine art, it's applied art.
I asked Mr. Sumption what was the reasoning behind giving a shorter period for works of artistic craftsmanship, because as opposed to sculpture.
It's only a shorter period if it's applied industrially.
Yes, that's implied in industrially. And
Yes.
Is it the same kind of thinking behind the limited life of the patent? And once you've given sufficient reward to the inventor, it's very desirable that there should be no restriction on its mass production.
I would say yes, Lord, yes. Yes. Yes, it is analogous to the this whole interface between copyright and industrial designs. It is indeed analogous to the underlying principle of a patent that it shouldn't last forever. And some might say that it was unduly unkind to the creator of a work of artistic craftsmanship. After all, copyright is not a monopoly. People can go and design their own costumes. But Parliament decided that even the most meritorious work of artistic craftsmanship, if applied industrially, should lose its copyright after 25 years. That, I say, tells one rather a lot about what sculpture was intended to be. It was indeed intended to be things with very small functional content. And costumes are way outside the scope of what sculpture's intended to embrace. Interestingly, the work of artistic craft, the point in this case was taken, first instance, that these were works of artistic craftsmanship. And Mr. Justice Mann accepted that Mr. Ainsworth was a craftsman. The problem, from the point of view of works of artistic craftsmanship, was that these were not artistic enough. It would be odd if they nevertheless qualified as a sculpture. There was no appeal against the finding that these were not works of artistic craftsmanship. Your Lordships haven't seen much of the Henshaw case, but there are, I would submit, things in the Henshaw case, although it's about works of artistic craftsmanship, that do throw some light on the way in which the question of sculpture should be approached. Firstly, I don't need that point. Let me take your Lordships to the Henshaw case, which is in Bundle 2 at tab 19. Tempting to jump right to the end and see what Lord Kilbrandon said on the last page of the bundle. He says about 6 lines down, I've endeavoured to show the reasons why it should be so. I've found no assistance in terms of the Act of 1911 or any other parts of the 1956 Act.
Where are you?
I'm so sorry. Towards the end of Lord Kilbrandon's judgment, he said, on page 29 of the tab 19 in Bundle 3, there's a little box which says copyright law is in essence, and about 6 lines above that, your Lordship's House has been offered definitions of the word artistic framed by each of Mr. Justice Graham, the Court of Appeal, counsel for the appellant, together with 2 by counsel for the respondent, has rejected all of them. In addition, I rather gather that there's no definition framed by a member of the appellate committee, which is altogether acceptable to any other member. This means that each of their lordships has rejected, or at least refrained from adopting, 9 solutions to the problem. It may be that Coppinger and Scone-James on copyright is right in saying copyright law is in essence concerned with the negative right of preventing the copying of physical material existing in the field of literature and the arts. Its object is to protect the writer and artist from the unlawful reproduction of his material. Since ample protection is provided aliundi for those preparing designs for commercial reproduction, it would not be doing any injustice were it be made clear that the Copyright Act is not concerned to protect, e.g., the Bronx prototype. So the simple approach he took in the end was to say, look at this thing, the Bronx prototype, described by a witness as commercial but horrible.
Commercial what?
Commercial but horrible.
Oh, yes.
I think the word was horrible. Vulgar. This, in effect, it's the elephant test. And it's the best test sometimes in situations like this. Claimants are trying to shoehorn things which don't belong into boxes which they don't fit into. And sometimes the best test is just to say, this is not a sculpture. It doesn't require minute analysis of the kind which your lordships have been exposed to from both sides. It's sufficient to say, this spaceman's outfit is not a uniform, is not a sculpture. But, my lords, I took your lordships to that because I think it's interesting to see that that was the ultimate conclusion of the case.
The furniture is described at page 4 of 29 by Lord Justice Russell.
Yes, it's a wonderful suite. It's horrible, it's vulgar, and it's brash. I'm afraid, unfortunately, the young people will go for it. I think there may be echoes of snobbery here again.
It was meant to look like a profile of an old ship with a poop at each end.
Yes. But the important point about this case is that this is an object which had very considerable eye appeal and was intended to appeal to the eye. In itself, it wasn't actually functional, or not very functional, because it was a mock-up. My learned friend's argument might suggest that it's a sculpture. And this particular one did better than the Denver suite and the Florida suite because it just happened to have an appearance that appealed more to the public. The question was whether it was an artistic work. The concession that it was a work of craftsmanship means that this case is, in a sense, on all fours with this case, so far as works of artistic craftsmanship are concerned, because the judge accepted that Mr. Ainsworth was indeed a craftsman. The skill of transforming this, which is the starting point, into this, is a craftsman-like skill. You have to make a mold. You have to heat this until it's soft, and then you have carefully to vacuum it down onto a suitably shaped former to make the individual components, and then you assemble them with nuts and bolts. Now that was a craftsman-like activity, and therefore the concession in Henshaw and Restawhile that was craftsman-like activity there meant that the House of Lords were considering essentially the same point in relation to the horrible Bronx suite as Mr. Justice Mann was considering in relation to this. And Mr. Justice Mann decided that this did not match up to the requirement of artistry to be distilled out of the Henshaw case. Now, if it didn't, then it would be odd, I would submit, that it should nevertheless be regarded as a sculpture. One possible point is that works of artistic craftsmanship don't have the magic words in the Act after them, irrespective of artistic quality. But Henshaw and Restawhile makes it clear in a number of places. For example, Viscount Dillon at page 20 and Lord Simon at page 26 and Lord Kilbrandon at page 28. Let me take it out of Lord Kilbrandon. Just at the bottom of page 27, Lord Kilbrandon comes on to deal with the question of artistry. The very last sentence there: it must be possible to deduce the conscious purpose of artistic creation from the work itself or from the circumstances of its creation. But this act arises only when the question whether it's a work of art becomes one for discussion or decision by others than the author. Merit is another matter altogether. It's been said that the courts will be reluctant to make aesthetic appreciations, and that's right. Not because to do so is difficult for a judge is for a judge difficult or unseemly, but because it's a decision which in this context is not required. So the approach taken to the issue of works of artistic craftsmanship in Henshaw and Restawhile was as indifferent to the issue of artistic merit as the decisions which are made in relation to sculpture. And similar passages are to be found in the speech of Lord Simon on page 26. In the first complete paragraph on page 26, about 10 lines down, not only is artistic merit irrelevant as a matter of statutory construction, evaluation of artistic merit is not a task for which judges have any training or general aptitude. And Viscount Dillon at page 20. 4 complete passages down, a short paragraph. I'm conscious, as was the Court of Appeal, of the need to avoid judicial assessment of artistic merits or quality, but I don't think that any such assessment is involved in deciding whether a work is an artistic work. So, my Lords, as a starting point, one can say that although there appears to be a difference in the 1956 Act between the treatment accorded to sculpture and works of artistic craftsmanship, in that the words irrespective of artistic merit are not tacked on to the end of works of artistic craftsmanship, one can see from this decision that the absence of those words makes no difference. And indeed, one can also see from this that the presence of those words in relation to the other works, in the the 1956 Act, make no difference either. There's something which was implicit in the definitions of copyright works, even without those words.
Shall we adjourn until tomorrow?